All right, Mr. Chair, the YouTube is live, so whenever you'd like to start.
Okay, thank you. Good afternoon, everyone. In accordance with Section 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. May I ask before we proceed that we all just take a moment to remember that today is the 80th anniversary of D-Day, a day on which many people sacrificed their lives so that we can enjoy the freedoms that we have today. Before I go on, I just want to introduce the members of the panel and the support staff that are here today to help out. On my far left, we have Natalia Popovic, a panel member. On my immediate left, Stan Komorik. My immediate right, Laura Alderson. Far right, Bill Dalton. I'm Don Taylor. I'm chairing today. And we have Philip Carvalho, our Deputy Secretary Treasurer, and additional support staff. The Committee of Adjustment considers applications for variances from the provisions of the zoning that applies to property, permission to extend or alter lawful non-conforming uses, and consent to sever property to create new lots. We acknowledge that the land we're meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Committee of Adjustment public hearings are now conducted in a hybrid in-person and virtual format. Some applicants and participants will make their submissions in person, and others will participate virtually by electronic means through WebEx, an online digital platform. The meetings are also streamed on the Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch on YouTube. Those who want to participate virtually and have registered in advance will be connecting with their computer, tablet, smartphone, or telephone, and have the option of participating via video or audio only. All virtual participants will automatically be muted on entry. When your item is called, you will be unmuted by the moderator, one person at a time. We ask that you also mute your devices until you are called on to speak. Those participating by video appearance will be temporarily upgraded to panelist when your item is being held. During this time, your camera will be enabled. You will only be visible during your 5-minute allotted speaking time. At all other times, your video will be disabled and you will be reinstated as an attendee. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Those participating through WebEx are not allowed to use share screen or any other panelist controls during a video appearance. The host will remove you from the panelist role if you fail to respect this instruction. People attending in person today who want to receive a copy of the decision of the committee on an application must fill out a decision request card, and those participating virtually need to submit a written request for a decision by email. Please ensure that you include your name, address, and email address because the Committee of Adjustment and the Toronto Local Appeal Body will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee, you may be able to appeal the decision to the Toronto Local Appeal Body, TLAB, or in some limited circumstances to the Ontario Land Tribunal, OLT. However, the provincial government amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies, as those terms are defined in the Planning Act, are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. I will call each item in the order listed on the agenda. Where an application is uncontested, the agent or applicant may proceed with their presentation if desired. When the committee does not require a presentation, applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions or take the matter into committee for a decision. Each speaker, including the applicant agent, will be given a maximum of 5 minutes to address the committee. I will comment when you are reaching the 5 minutes. Any presentation or other materials you wish to submit to the committee must have been emailed in advance of the hearing. Staff and committee members cannot accept materials at the hearing. When addressing the committee, please clearly state your name and address. Please remember to confine your remarks to the matters outlined in the application. The applicant or agent will proceed first and will make a presentation to the committee on the application. Please note that the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application if substantially revised to ensure the revised application is accurate and that all those entitled to notice of the application are informed of the changes. Then, individuals either in support or opposed to the application will be invited to speak. Generally, we first call on speakers in the hearing room and then those participating through WebEx. Committee members may ask questions of each speaker after they have finished their presentation. When all speakers are finished, the applicant agent has an opportunity to rebut only those issues that were raised by the speakers. This will mark the end of the discussion. The application will then be taken into committee for a decision. Okay, I would ask our panel and staff if there are any declarations of interest for items in this afternoon time slot. Panel? None? Staff? None? Okay, thank you. Mr. Deputy Secretary Treasurer, have you received any requests for deferral in this time slot? None, okay. And have you received any files to be closed? No, okay, good. Alrighty then, we can proceed with the agenda. We're starting with item number 15, which is a consent, which is 82 Ash Crescent. It's a consent application and 2 minor variance applications, one related to each of the proposed parts. We have urban forestry conditions requesting refusal, but offering fallback conditions 1 and 2. We have heritage planning conditions. There are 4 of them. We have engineering and construction services and transportation services conditions. We have a favorable report from community planning. We have 11 letters of opposition, 2 support letters, and an arborist report. So can we first call on the agent, Jason Fung?
Yes, speaking.
Yes, Mr. Fung. Okay, could you please present your client's proposal for consent and variances? And I just will mention right now that we do have an in-person participant and we have 4 online. Okay. So, okay, Mr. Fung, can you tell us about your proposal?
Sure. Yeah. Hello, Mr. Chair and members of the committee. My name is Jason Fung. I am the architect and agent. I'm located at 675 King Street West, Toronto. I'll just dive in. So this proposal is pretty straightforward. It's to split an existing 15.5 meter wide lot to be 2 smaller 7.7-ish meter wide lots, effectively turning a single family dwelling into 2 single family detached dwellings. The owner and I spent a fair bit of time to develop a proposal that would be both sensitive to the fabric of the community. We understand that there is resistance to change in this part of the city. So as an approach, we match the overall massing to our direct east neighbor. That's to the top of the page, what you see there, at 78 and 76 Ash, along with having support from our direct neighbor, our westerly neighbor at 84 Ash Crescent. I must note that we don't have any opposition from any of our direct neighbors. Working with community planning at the city for the past few months, we believe we have their support as well. And we have made updates to satisfy their concerns, namely the side yard setbacks in between the two houses that we're proposing. Originally, we're at 0.35 meters each, and we've increased it to 0.45 meters each, so that between the buildings it's 0.9 meters. The outside side yard setbacks, there's no variance for that. We are meeting the bylaw at 0.9 meters. From a soft landscaping perspective, we initially had 28% and 26% for the two lots, but we've increased that to 40% for both properties. The required is 50%. In terms of maximum floor space index for these lots, it's proposed to be at 60% or 0.6 of the lot area, in keeping with many of the houses in this area. We feel that increase in density is within reason, considering there's densification happening. Like just north of us is Lakeshore, and then just west of us there's already a approved 4-story multi-residential building to the west corner of Ash Crescent. And so overall, I mean, I feel this is a very sensible proposal, and with respect, we hope that the committee views this proposal positively and hope it will be approved. The final page of the drawings has our rendering of what we're trying to do, and you can see project to the existing condition to the east. To the west, it's kind of strange. It's a drive aisle to the house. To the building that touches onto Lakeshore. I'm open for any questions.
Okay, thank you. Panel, any questions for Mr. Fung before we proceed?
I'd like to ask my favorite question for this sort of situation.
Yep.
Mr. Fung, have your clients considered, or why are you doing why you're not doing two semis as opposed to two standalone houses with very slim space in between?
No, that's fair. So to the east, actually 78 and 76 Ash right beside us, they're massed exactly the same as detached dwellings. So we're continuing that fabric of detached on slightly smaller lots. And then 84 becomes kind of a buffer. I mean, in the area, it's a lot of single family houses. So we're just in keeping with the fabric. And there's a marketability aspect to it as well.
Yeah, that's fair. I'll come back to this theme because, I think planning, you had mentioned that planning was not happy with 0.35. Quite frankly, I'm not happy with 0.45, but we'll come back to that. Thank you.
Okay, so we can proceed now with registered speakers. And we'll first invite the person in the room. And I think is it Gabby Cordero? Hello, ma'am. Just come up and repeat your name and give us your address and make your presentation.
My name is Gabby Cordero. I'm at 8 Birchley Avenue. I am speaking on behalf of the Long Branch Association for Judy Gibson. Am I too loud? All right. So I reside around the corner. Today I've been asked to depute on behalf of the LBNA Tree Preservation and Enhancement Committee. I wish to address the issues raised by Judy Gibson's letter. The chair of this subcommittee, which align with the recommendation of refusal from Urban Forestry. If you go into page 1 of Ms. Gibson's letter, the proposed severance and variances will remove 2 significant trees, a 30 cm GBH birch on the city boulevard and a 54 DBH private sugar maple. Both of these trees could be preserved without severance and an application with preservation in mind. Both these trees are protected in accordance to the City of Toronto Bylaw 513, but if you choose to approve this application, both these trees will be removed and the character and benefits of these trees on Ash and in border neighborhood will be lost. With a different plan, we could preserve both these trees. The birch is the only one on Ash, and according to our Long Branch tree inventory, which has been ongoing since 2018, It is a rare species to find in Long Branch and equally unusual to find one of this diameter. Please go on to the next page of Judy's. Are you looking at Judy's letter? Maybe not. In 2019, a U of T student studied the effects of severances on our mature tree canopy. The conclusions were quite clear. On the residential lots where a severance occurred, there was 50% canopy loss and a 24% loss on the adjacent lots over the 40 lots studied. The City of Toronto's strategic management plan has a goal to protect and expand the urban forestry canopy coverage of 40%. These trees contribute to that goal, and the small replacement will not offer the same advantages of shade, carbon sequestration, and other benefits within our lifetime. This application contradicts the City's Council resolution on October 2nd of 2019, which declared a climate emergency, emphasizing the protection of Toronto's economy, ecosystems, and community for climate change. Furthermore, the launch of Toronto's first resilience strategy underscores the importance of enhancing resilience to climate change and including mitigating hazards of flooding and heat. Several variances requested in this application are not minor and pose significant concerns. Significant lot frontage and area reduction, significant floor space index above the maximum, significant side yard reductions, inadequate front yard softscaping. These variances will, when looking through the lens of the official plan policies, justifies urban forestry's recommendation of refusal. So the survival of these trees are in your hands, and should you choose to approve this application, urban forestry will issue permits to remove these trees on site and leave another hole in our tree canopy. To be clear, approving the forestry conditions will not preserve these trees. So we would respectfully request that you refuse this application, as these variances undermine the four tests under the Planning Act. That's where I'm at. Do you want to ask me any questions?
Any questions for Ms. Cordero?
Well, can I add a few things to this? There are underground rivers on the lakeshore and south, all the way down to the lake. This property ends up on a V shape where there's two rivers that connect underground. The resulting damage of all the overbuilds in our watershed where we live is causing water damage to our houses, and there's no insurance for water damage. That's excluded on everybody's policy.
Okay, are there any questions for Ms. Cordero? Okay, so no one else in the room here to speak to 82 Ash Crescent?
According to my records, that is correct, Mr. Chair.
Okay, so we'll move to the virtual participants then. The first up would be Stephen Vella. Mr. Vella?
Hi, how are you?
Yeah, good morning, or good afternoon. Yeah, if you just give us your name and address and then your presentation, please.
Yes, Stephen Bella at 42 Ash Crescent. My family and I have lived in Long Branch. Oh, can you pull up my letter, please?
It's on the way.
Thank you. If you can pause the clock, please, until it appears. Thank you. Thank you very much. This development needs to be deferred or outright refused. There is so much fog with this application, I do not know what the applicant is actually asking for. The list of missing variances and application errors is significant. In the notice of public hearing, the applicant wants to sever an existing 50-foot lot into two 25-foot lots and build two detached dwellings with an integrated garage. Except the plans that are submitted show the severance, but the houses do not have an attached garage. There is no garage in the plans at all. The side yard setbacks are recently changed, so I did not have a chance to review. But the applicant originally identified the minimum east side yard setback as 0.9 and asked for a variance of 0.45. And they do not identify the west side yard variances they need. But the issue is the minimum side yard setbacks are 1.2 meters for this property. The arborist report is also new, and I didn't have a chance to look at that. It wasn't added in time. When looking at the renderings of the application, it's misleading. It does not show an attached garage, and with the errors in the side yard setback, it is not possible that the renderings will ever be built. When you get the real side yard setbacks that they'll ask for at a further stage, the houses will have to be narrower, where they'll lose FSI. It won't look like this. It won't look like this. I've been attending the COA hearings for almost 10 years. And every time there is a severance application, the applicant is asking to remove an affordable family home and replace it with 2 overpriced homes for millionaires and/or investors. This is not housing that the city needs. This is housing at all cost. Not only is the cost the selling price, but also the cost to the neighborhood. This development will remove large canopy trees and trees that would grow into a large canopy trees. And the canopy trees are the character of Ash Crescent. If the severance is approved, there will be so much competition for the leftover plantable space that any new trees that are planted will not be able to grow to maturity. Large canopy trees cannot thrive when they have to compete with house services like sewer and water, and also the driveways that take up a lot of the space and prevent growth. If this is approved, the creation of oversized houses on undersized lots will forever loom over the neighbors, all for the short-term financial goal of a developer. With this new appeal limitation, nature and the neighborhood only has one chance. If development is approved at the COA, the neighbor is unable to appeal to TLAB to stop the severance and save the existing mature trees and the plantable space for the future. I wish our family would have bought this property and they were in the process of developing for themselves. This existing property is the perfect fixer-upper or as livable as it is today. If the developer needed to buy a property which could be severed to support their business plan, they should have bought land that was large enough to be able to be severed. This property is not. In Long Branch, since the 60s, lots were required to be 12 meters or 40 feet wide. Developers buying property in the wrong neighborhood is part of the reason for the unaffordability of housing. The only way this can be stopped is by holding developers up to the standards the city has set out. If I can quote from the city's official plan, that the key objective of the city's official plan is that the development in established neighborhoods will respect and reinforce the existing physical character of the neighborhood. No changes will be made to rezoning, minor variance, consent, or other public action that are out of keeping with the physical character of the neighborhood. The development proposed at Etobicoke Ash accentuates the problem with bad planning begets more bad planning. In the waning days of the ONB, they allowed Long Branch severances. That is how 76 Ash received approval. The severance and development of 76 Ash was refused at the COA in September 2011, but was approved by the ONB in March of 2012. Since the creation of TLAB, not one severance has been approved in Long Branch and 21 have been refused. TLAB took a much more neighborhood-focused view to the development request than the OMB. In the most recent TLAB hearing on Ash Crescent was for 90 Ash. After 10 TLAB hearing days, the application was refused. Member Yao stated, I have found extensive reasons.
Mr. Vella, you have 20 seconds. Mr. Vella, you have 20 seconds to close. Thank you.
Okay. Refusing because of the severance is important, as the severance removes the existing mature trees and removes viable planting space for the new trees to grow. This is why what 76 Ash Crescent looked like before development, a few years later, and the last picture is current. And I think those pictures speak for themselves. Thank you.
Thank you. Panel, any questions for Mr. Vella? None? Okay, we'll move down to the next registered speaker is Alexander Sandy Donald. Mr. Donald?
Yes, my name is Sandy Donald. I'm from 3436th Street. This application is not complete and should not be presented to the Committee of Adjustment. The notice does not match the drawings. One side set yard setback should be 2. Also, the bylaw is 1.2, not 0.9, which they repeatedly state. The character guidelines report is way off the mark. There's just not enough information for the Committee of Adjustments to make a fair decision. Is this application minor? For this application, the size of the variances range from 73%, 71%, 63%, 48, 44, 37, 18. The number of variances, including the ones missing, is 22. And the impact of these variances is not minor. The FSI variance of 0.6 is almost double the bylaw of 0.35. The sheer number of variances, some of the sizes cannot be considered minor. To say this is minor is complete distortion of the word. Big is not small, slow is not fast. Variants of these magnitudes should not or do not meet the test of minor. To put this into context, the speed limit on the 400 is 100 kilometers an hour. If you went 73% over the thing, you'd be talking 173 kilometers per hour. Your car, if stopped by the police, would be impounded, and the police probably would ask you if you've been drinking. This is just not minor. Mentioned for the general intent purpose of the official plan, the key thing is the cornerstone policy is to ensure that new development in our neighborhoods respect the existing character of the area, reinforce the stability of the neighborhood. It says this at least 18 times. The rest of it, actually, Steve Vella has already mentioned. Intent of the Long Branch zoning bylaws. And this is a quote from the OMB decision for 3036th Street. If the council that drafted the original FSI bylaws had wanted to see lots with FSIs of 0.5 or even 0.75, they have made these the standards. This application has to give a valid reason why the bylaw requirements cannot be met. It is difficult to understand how two oversized houses can be built on a undersized lot that meets the bylaws. This application fails the test of meeting the general intent and purpose of the zoning bylaws. On the character guidelines,
It's got lots of time. That's fine.
the object of the guidelines is to attempt to identify the neighborhood's key characteristics, defining qualities, and ensure the future developments are designed in a manner which is contextually sensitive and responsive to the neighborhood characters with policy 4.1.5. The character guidelines is the city council giving written character references to Long Branch. The actual, I put in there, I went through on the character guidelines on what fits, what doesn't, whether it fails or complies. The actual character guideline that was submitted by the developer, I think in only 4 cases do they actually talk about it, and all the rest are saying it's not applicable. Well, they are applicable. You can't just ignore it. Based on ours, and you might say some of ours are not necessarily you would agree with, but we got 14 out of 16 cases where it fails. Even if you take that down to 12 or something like that, in the majority of the cases, this fails the character guidelines. Therefore, according to the City of Toronto, it fails the character of Long Branch, and basically it fails 4.1.5. That was my sort of key stuff there. First of all, I do not think it's reasonable that the public notice, where this varies as much as it does from the public notice, I don't think that's sort of fair and reasonable. And this just does not fit. Thank you very much.
Thank you. Panel, any questions for Mr. Donald? Could I ask staff to confirm the side yard? It's minimum required side yard stated as 0.9. Mr. Donald suggests that it's 1.2. Yeah, okay. I did notice that. Yep. Okay, thank you. Moving on then to the next virtual participant, Christine Mercado. Ms. Mercado?
Start from whatever was just given. So would that be repeated, please? Because we all have a real problem with the mistake.
Christine, sorry to interrupt, but we can barely even hear you. It sounds like you're extremely muffled. Maybe you could move the microphone a bit around or get a bit closer to it. I'm not totally sure, but we can barely even hear you. Christine Mercado?
Is this better?
There we go.
Yes, is this better?
Thank you.
Is this better?
Yeah,
Okay.
please.
Okay, so back to my question, because whatever Philip actually just said on the record was not audible online. So could you repeat that? Because we all have a problem with this side yard setback mistake on the public notice.
The zoning information that's being sought is provided by the building staff. We as city staff, Committee of Adjustment, are not applying the bylaw. We just process the application as submitted, and the applicant did submit the application with that request. If it's incorrect, then they will not get a building permit, and they'll have to come back. But we process applications as they are submitted. We don't do zoning reviews. We process waivers and zoning notices that are submitted with the application.
I guess I just have that's a real problem with the system, because it actually is outlined in my letter, and I've outlined it quite clearly in my letter that this is a mistake, and this application was done under zoning waiver, and they're very resistant to acknowledge the fact that that side yard setback is wrong.
Christine, are you still there?
I am.
Oh, perfect.
Can you hear me?
Yep.
This has not been a good day. Okay, so test.
Hello.
Can you hear me?
Yep.
Yes. Okay. Thank you so much. My name is Christine Mercado, and I'm the chair of the Long Branch Neighborhood Association, and we're here to object to this application as it does not meet the 4 tests or the criteria for consent. Our letter contains facts and data that prove that this application of a severance to 2 deficient lots, 2 overbuilds, removing all significant and protected trees, present a character change on ash. Our sources are the City of Toronto data, current COA and TLAB decisions, and knowing and living the neighborhood. The applicant has provided no evidence or data providing that their application meets the 4 tests, which is their burden to bear. So if staff goes to page 10 of my letter, we've highlighted the relevant parts of policy B, C, G, H, and I, where the application falls short of the test of prevailing characteristics. We have defined a geographic neighborhood as required by the OP using the 5-minute walk zoning in historical Pine Beach neighborhood using current policy. And there has been no severances since the clarification offered by OPA 320 and the approval of the Long Branch neighborhood character guidelines. So anything on the ground is under a previous version of the official plan, and is very much one of the reasons that we do have Long Branch character guidelines. The result is a street that's fairly balanced with lots of record and wide frontages that are bylaw compliant. So if you go to section 2 and then go on to the next page, 14, the guidelines clarify 4.1.5b lot frontage and area policies by stating that new severances that produce lots less than 9-meter frontage do not meet the intent and purpose of the bylaw. These guidelines have standing at TLAB, and we have many decisions using this clarifying document. Previous decisions are 90 Ash, 10 Lake Promenade, 82 27th, 99 27th, 11 Shamrock, 38 31st, and 80 23rd. In section 3, page 16, in the broader context outlined in red, we've illustrated the prevailing frontage is 12 meter or larger, and that's in the light green. In the immediate outlined in orange, 52% of the lots meeting the bylaw minimum for frontage and the minimum frontage established in the guidelines. That's light and dark green. So if you add in East Ash, which is outlined in purple on the map, this prevailing characteristic increases to 74%. So that's what's prevailing. In section 4, and then just go to the next map, in the immediate context, 52% of the lot areas meet the bylaw, which also increases when you add East Ash. Go into section 5 in the next map. We also examined FSI, and 59% meet the bylaw. FSI was also examined recently in the 90 Ash T-Lab decision, where 0.60 was identified as a broader context as the upper 6% of the neighborhood, so quite large. And this fact has not changed and is highlighted in section 9 of my letter. In section 6, which is, and then go to the next page, we've highlighted all the guidelines of concern, and I want to point you towards F. The guideline does consider severances if the result is 9-meter frontage or more. And it also states that under 8 meters does not meet the intent and purpose of the bylaw, which is on page 21 of the guideline. I also visited this section of Ash and looked for a 0.45 setback, as a mistake in the public notice really bothered me. I physically measured the setbacks and it does not exist. So it's not only much smaller than the 1.2 that's required, it doesn't exist, which is contrary to policy 4.1.5G for failing side yard setbacks. So in section 7 on page 24, it really comes down to the severance has the biggest problem. The change in lot configuration drastically changes the length of the home, so it doesn't fit, creating long blank walls for neighbors, fuels a domino effect for more severances, and removes trees. This is outlined, and this domino effect is the part that bothers the neighbors the most, and it's outlined in the letters that this committee has received. So in section 8, page 27, trees are important to the character of Long Branch, and the association has partnered with U of T and studied, and we know that severance activity is the biggest remover of trees. The guidelines state that the new development should not result in the loss of mature trees, and the guidelines examples right next door where the remaining injured spruce tree is in significant decline and doubtful to survive. Recent severances have been proposed at 90 Ash, 55 Ash, 18 Ash, 99 27th, 82 27th, and 11 Shamrock.
Ms.
And are all
Mercado,
recently
Ms. Mercado,
reviewed
you
by
have,
TLAP.
Ms. Mercado, you have 15 seconds to wrap. Thank you.
Thank you. Okay. There's no information in this file that proves that the severances approve, that remove trees or meet the tests. So we've provided significant facts, decisions, and data, and we respectfully ask the committee refuse this application.
Okay, thank you very much. Panel, any questions for Ms. Mercado?
Yes.
Yes, Mr. Dalton.
On diagram 4 in your letter, there appears to be about 8 parcels between 31st and 28th Street, which I'm assuming were varied. Were they all done pre-OPA 320?
Okay, so are we talking about north side or south side?
Well, you have 82 Ash denoted as the yellow star, correct?
Correct. Yes.
Okay. And then you've got 1, 2, 3, 4, 5 parcels in red, 2 in navy blue, 1 in black. Noting they are exceeding the lot area for this area.
Correct.
So the question is, were they all done pre-OPA 320 or were they post-OPA 320?
They were all pre-OPA 320.
Thank you.
Any other questions for Ms. Mercado? I think our final speaker then is Vanita Indaway. Ms. Indaway?
Hi.
Hi.
Can you hear me okay?
Yeah, can you just repeat your name and give us your address and then make your presentation? Thank you.
Yes. My name is Vanita Indaway, and I am a resident at 59 Ash Crescent, just down from 82. So I will state that I oppose the effort to split yet another lot into two small lots with overbuilt forms and hardscape and driveway that leaves very little green space in the design. I think that my colleagues have adequately provided ample reason to deny the application based on the details and built form, so I won't go over those details again. Mr. Fung mentioned that the new homes are in keeping with the fabric, but this is only relevant, pointed out in the context of the Committee of Adjustment and OMB decisions in recent years that allow for the reducing of lot sizes because of splitting and the building of oversized homes. Christine pointed to other parts of the same neighborhood, and you can see that most are not of this built form. This proposal happens to be beside two of the same, so it looks congruent. When the first application to split a lot on this block was made next door to 82 at 78 and 76 Ash, I recall that OMB Chair Mr. Lord, in his decision, said the neighbors had no reason to believe that an approval to sever and grant variances would lead to more of the same changes. Today, on this single block, and only on the north side, there are 3 50-foot lots that have been split, 2 others that have been denied on their first try of Committee of Adjustment, and they have sold since, so I'm sure they'll be back. And now 82 Ash is under this same axe. I do understand that this committee makes decisions based on the merit of each case, but I would ask that you consider the larger context of decisions to approve these exceptions, which indeed have become the trend and consume your and our time. I ask the committee to make decisions on these applications that reflect the long-term commitment of the City of Toronto's planning initiatives, and that is develop along the corridors, including Lakeshore Boulevard West, build more affordable housing, and increase the tree canopy by 40%. Applications like this meet none of these requirements. And you know, as much as the city, I'm sure, has good intentions in creating bylaws, et cetera, we are consistently breaking our own rules and are in fact working against planning for affordable housing by removing a smaller in square footage but very livable house and cutting down another 2 trees and reducing any future opportunity to increase planting on this lot. The neighborhood and the city have been working together diligently to plant more trees in the neighborhood. I've been a guest in this house. I've enjoyed the backyard, and removing it from the marketplace to replace it with 2 more expensive homes is insupportable. The last thing I would ask in light of what's been shared in this particular meeting is, given that the residents no longer have an avenue of appeal to Committee of Adjustment decisions as we did in the past, it's important to use all of the information that is provided by the applicant and that it is accurate. So my question is, in the Committee of Adjustment review of the application for 54 Ash, I recall that that applicant had some inaccuracies, and the committee on that day asked the applicant to come back with a revised, corrected application, which they did. That application was then denied. If the applicant's proposal in this case relative to zoning is incorrect and a permit is denied, will the applicant then need to come back to Committee of Adjustment again so that we can hear and discuss with the corrected version? So that's the last thing I have to say. It's really a question. If they are denied a permit, do they have to come back to Committee of Adjustment?
Yeah, yes, they would.
Okay.
If they're denied
So
a
thank you
permit
for
because
hearing.
they require variances they didn't get, yes, they'd have to come back.
Okay, thank
Yeah.
you for
Okay,
helping me educate myself about this process.
not a problem.
And I would ask that you deny this.
Yeah, okay, yep, I think we understand that. Panel, any questions for Ms. Indaway? Okay, Mr. Fung, it's your turn to rebut what you've just heard from the 5 speakers.
Yes. I'll start with the trees. So yes, there are 2 trees that do need to get removed for this application. The one at the front yard is a white birch, as mentioned, and it's in the way of the driveways. There's no real way around any kind of construction without removing that tree. And the other is a sugar maple that's actually touching the existing house. It's in decline, as per the arborist report. So we will be planting 4 new trees, as per the arborist report, in lieu of cutting down those 2. So that's how we will address that with our tree permit. there was a comment about the garage. There is no garage in our application. There is a clerical error in, I think, early on in a title that was like this application for with an attached garage. But anyway, that's been removed. There's no garage for sure. In terms of the 0.9 versus 1.2 meter setback, the zoning's pretty clear that lot width between 6 meters and 12 meters, the side yard setback is 0.9. Since we are severing this lot, it hikes down into that thinner lot frontage. Yeah, I do want to. I want to say, like, the north side of Ash is kind of an interesting. It's an interesting street because we could think of it as the south side of Lakeshore Boulevard, which is allowed to be now 6 stories. So we are, if anything, kind of stepping down the density into the Lawn Branch zone, and we're trying to do it as nicely as possible with our proposal. So I think I've addressed most of the outstanding questions. Yeah, if you have any other questions, please, I'm all ears.
Panel, any questions for Mr. Fung?
I have a few, if I may,
Yep.
Mr. Chair.
Mr. McCormick, go ahead.
Okay, Mr. Fung, first off, I'm just going to confirm you're not providing parking on either site?
It'll be a parking pad, essentially. In the
So you are going to request a parking pad? Okay.
Yeah, essentially, yes. Yeah.
Okay. Is there a proposal for garden suites on these as well?
No.
No, okay. So my main question is, can you provide us with any examples of a 0.45 setback anywhere in this neighborhood?
Oh. I think I can. There are a couple splits. Yeah, I mean, there are a couple splits that the buildings are quite close together. But 0.45, I mean, when I talked to community planning, they were quite pleased with 4.5, so that there would at least be a 0.9 setback between buildings. Off the top of my head, I mean,
but this will be between 2 buildings. I mean, you're going to sell these properties to individual owners. If someone puts a fence down the middle of this, you're looking at less than 1.5 feet, which is pretty much not usable.
Yeah. I mean, we weren't planning to put any fences in between.
Well, of course you're not.
Actually, between 78 and 76 are very close together. I think those are actually 0.45 between property lines, right next to us.
I'm not so sure, but
yeah. Let's see here. I'm just looking up here. Oh yes, they are very close together. It's about 1 meter between the 2 houses right next to us.
Yeah, mistakes were made in the past. Okay. I think that's concludes my questions. Thank you.
Any other questions?
Thank you.
For Mr. Fung before we move into committee? No? Okay, then let's go into committee for a decision on the consent and the 2 minor variance applications. And again, just to summarize, we have Urban Forestry requesting either refusal or conditions 1 and 2. Heritage Planning conditions 4. Engineering and Construction Services and Transportation Services. And that would be it. So could we have a motion with reasons?
Yeah, I'm good to go. Yeah.
Okay, Mr. Kimura.
I'm going to move a motion to refuse. Basically, my concern is a setback facing to the 2 houses. I think at some point in the future that could just become an untenable situation. If this was, in the inner city where you have a right-of-way between the 2 of them, maybe. But, I mean, this comparable to all the comments I've made on all the previous severances, which were at least 0.6 .45 in my view is just insufficient and not tenable. And for that reason, I don't believe the application is appropriate.
Is there a seconder for Mr. Komorik's motion?
Yes, Mr. Chair, I'll second that motion.
Seconded by Ms. Popovic. Okay. All in favor to refuse the application? Beg your pardon? Sure, go ahead and make a statement.
Well, along with that, I just find that the applicant should have submitted more supporting documents to justify the variances, because I'd like to approve it, but I want to see some precedents to counter the information that the Long Branch community brought here. So if they were able to counter that, I would have been able to get there, but I can't get there.
Yeah, and I think I'll just comment too. I think with respect to the people that spoke, I think they need to be aware that had this been an application for 2 semi-detached dwellings, there's a very strong likelihood we would have moved to approve it. Anyway, I think the motion's been made to refuse, seconded.
I think we haven't voted in.
We haven't voted yet. All in favor? That is unanimous. Refused unanimously. Thank you all for your participation. Okay. Item number 16 is 13 Elder Avenue. The purpose is to permit a landscaping deficiency to accommodate an existing swimming pool in the rear yard. This is a deferral of a matter that was before this committee on August the 31st, 2023, and it was deferred on that date in order to provide the applicant an opportunity to provide a fulsome site plan, including soft landscaping, a site photo depicting the proposal, and an indication of the feasibility of increasing soft landscaping. I would just note that in comparing the variances requested in August 23 and that requested today, there is no difference. We have a Metrolinx advisory associated with this application, and we have planning, community planning expressing opposition for the same reasons as they expressed in August 2023. So, the agent is Alexander Kaplanov. That's you, sir?
Yes, sir.
Okay, if you can just repeat your name and your address and make your presentation.
Yeah, absolutely. Alexander Kaplanov, sorry, for 13 Elder Avenue. And thank you for having me back. So just to kind of reiterate a little bit what you said, plus what sort of happened last time, we had provided a submission to do a fence permit with a design for the pool, including a soft and hard landscaping, everything that was there present, plus that was going to be built. That was approved based on all the drawings, which when we had come back to close the fence permit and review, they let us know that they didn't actually look at the metrics and the metrics seemed wrong. And then when we reviewed the metrics with them again, we had to go back and say, okay, they were wrong. No one seemed to have looked at the metrics, and it came back as 33% instead of 50%. So I guess to your point, just kind of going back to why it's not submitted differently is because it's an existing structure. We're not building. This was already done and is already done, so we had to come back asking for this variance after the pool had already been put together. So from last time, you just asked to get some pictures to see what it looks like. We did that. The pool represents a large part of the, I guess, backyard. It represents a soft landscaping. We have some garden greenery around it, but as it was designed, we needed a significant amount of concrete around it for load-bearing walls, and that sort of made a large portion of this backyard. Alongside of all of that, when you sort of asked last time, you asked to engage in construction companies or contractors to opine on whether we can just rip out the concrete or change the concrete, because myself, my wife, and I guess yourselves were not construction experts, so we had to understand a little bit more in depth what can be done and what are the repercussions of doing that. So I had gone out, spoke to about 12 contractors a lot of them didn't care to show up or want to provide me letters. I got 4 in total that came back and said that, as well, including the pool company, that kind of reiterated back that the way they designed it, the way it's been developed, it's kind of one piece of concrete, so you can't just rip out one portion without potential long-term damage to the rest of it, and they would never recommend it. The other companies we spoke to, they kind of reiterated similar idea, and that they would never want to take on that work because, again, they're kind of at risk of, like, what if there's a crack to the rest of the concrete? It's kind of like one foundational piece, and what if that load-bearing piece pushes in, and then you have a large pool, large body of water, potentially presenting damage to the neighbors. So that is sort of what I put together. That's what we got since last time. And yeah, just here to get that variance. When we looked at it last time, there was about 10 variances in the neighborhood that got approved, potentially more since then, that had under 50%, some as low as 27%. And it wasn't because they had a laneway or a driveway in the back. It was similar, kind of single detached with a backyard. So I don't want to go over time, figure to kind of go back to you. I think the only other thing was you asked me to reach out to Long Branch Association. I think we tried to get in touch. We never really heard back. Same idea of getting more people on the construction side, because she mentioned, and similar to all of us, we're not experts on that. But that's my application. Don't know if there's questions. That hopefully it's a little more straightforward than the last one. But.
Okay, panel, any questions? Ms. Alderson. Question.
Yeah, I'm just looking at this application right now. Is there any opportunity to increase the soft landscaping, either in the front or the back? I'm looking at the front yard right now. It looks like you have a double wide driveway. That's fairly long. It looks like you could accommodate almost 6 cars on that driveway. So I'm just wondering, is there an opportunity, if there's nothing you can do in the back, is there an opportunity for something in the front?
I think on the front would be open to it. We've never asked. You sort of remind me of winter and shoveling and how I'm not a fan of that. So I wouldn't be opposed to it. I couldn't answer that on the spot, but I think it's just what do they pour at the front? Just regular kind of. I don't think it's concrete, but I don't know the material that they pour.
Asphalt. It looks
Sorry,
like
asphalt. There we go. I'm blank for a second, but
relatively easy to.
That may be something that can be done. I know we've had Enbridge tear it up twice already, so potentially something that can be done.
That's why the patches are there, right?
Exactly.
Yeah.
Beautiful patches.
So yeah, so I was thinking that might be something to enhance the soft landscaping. On
Certainly open to that. If again, never asked, but asphalt I think is easier to rip up, and it's something that we were looking to redo at some point in the future because we bought the house built, so we never touched the front.
Any other questions?
I have a question as well.
Yep.
I think one of the things we also asked for you to come back is with some more details on on the site drawing. What you've come back with is the same site drawing, so I'm going to ask you for details on it because it's not really clear to me what's what here. It would have been helpful, maybe if we could get staff to pull it up.
Sure.
It would have been helpful to indicate on here in some kind of a fashion, either through darker color or hashing, to see what is permeable landscaping versus what is hardscaping.
Yeah, no problem. Obviously I can't do it on the spot, but if you.
Well, you're going to have to if you want to.
Yeah, no. I'm saying sorry. I meant like I couldn't actually draw on the spot.
No, understood.
Yeah, I guess so.
If we follow, like on the left-hand side,
yes,
it says undisturbed soil.
That's right.
And then there's a thin sliver that follows all the way around the perimeter. Is that correct?
Yeah. So it's about 2 feet on that side, about 1.5 feet on the south side, okay, and then about 2 feet on the right side, okay, in terms of all soil.
What is indicated as lower patio, is that hardscaping?
That's right.
Okay. And then you've got on the right side, if I'm the way we're looking at it, of the dwelling, it says paving stone.
Yeah.
Do you know what is the nature of those paving stone? Are they cement? Are they concrete? Are they?
There's stone that we put. We still have like grass and weeds grow around it.
So it is permeable?
Yes.
Okay.
Yeah, so I guess
Do we have any photos of that?
I don't know if we provided photos of the sides. I think because last time it was photos of the pool, so.
I'm going to see if I can zoom in and probably not.
Yeah, I don't think you can.
I don't think I can
Oh,
zoom
maybe,
in
sorry,
that
I'm not looking at
far.
that site.
I'm happy to share those, but obviously it may not pop up there.
I'm looking at Google Earth. It's 2020. It says it's 2024, but I mean, it's showing me a fair bit of grass in the back there, which I don't think is the case.
Let me just pull up so I can.
Sorry? Yeah. Because the pool's there, and I'm seeing grass between the pool and the house, which isn't reflected. Oh, that's the neighbor's pool. Does the neighbor behind you have a pool as well?
They do as well, yes.
Okay, so this is before your pool was installed.
Oh, that's weird. It doesn't even come up.
That
13
explains that. Okay.
Huh. Okay.
I guess what I was trying to struggle with here is that if that those paving stones could be made permeable, that would also.
Yeah, they are. Like I could physically pick them up and move it.
Well, I mean, you want something there. You don't want to be walking on mud either.
Yeah. No, well, that was kind of part of it. I mean, yeah, like I'm just on Google Maps, and I think this is the old drawing. It's just all grass.
Yeah.
Or not drawing, but sorry, picture.
I'm basically sort of following what Ms. Alderson has started was just to see if there's some way of increasing some percentage of the permeable surface.
Yeah, and if the committee is open to the front being increased, I mean, I think the asphalt can be decreased, and we're open to kind of finding a solution there.
Even if you kept the same width, and obviously the length is not going to change, but if you kept the same width and used permeable pavers in the front as opposed to asphalt, that would increase the opportunity for groundwater to be absorbed.
Well, even the walkway, which extends from the back right through to the front, if all of that were to be permeable pavers.
Both those are. There's no cement or anything on the walkways. I mean, we never did that.
Okay, so what material is actually there?
It's just stone and then a paving stone so that you could see like grass come out of it and everything.
Okay.
Or like my tiny stones.
Is there any other questions?
I was just wondering how that's, so for the deficiency, we're dealing with the rear yard only, so that would be only everything from the back wall.
Mm-hmm.
Yeah.
So we can't mitigate it by. Yes,
Yeah.
it's very holistic.
Yeah.
I have a question, Mr. Chair. The homeowner, sir?
Yes.
Looking at the back only, the photos of the pool.
Yep.
The stones around the pool, are those grouted?
It's not stones. It's just literally all concrete. Like they literally poured one slab of concrete with about like 4 feet around the pool that was reinforcement, and then everything is just continued on from there. So.
But there's a grid. Is that grouting between?
Yeah, they just did it manually. Like they literally like.
Oh, it's not. There's no way to.
Yeah, there's nothing in between. So, oddly enough, they like cut into it, so I get some weeds growing out of it. But there, to your thought, it's not like a piece that you can remove out.
Okay, thank you. We're just blue skying.
Yeah, of course.
That would mitigate it. Yeah, it's not going to change it. is an option too. Minimal.
Not a lot of area left there.
No. Yeah, exactly.
But it, yeah,
No.
but it is the beginning of the summer, and we want to make sure this pool is left intact because we want them to enjoy the pool this summer. But I'm just, I'm concerned about how to make this more eco-friendly in the back.
Totally appreciate the thinking. Yeah, I mean, we asked. That was sort of all we could do for the contractors and the pool company as well, if they've done anything like that to like reverse. And they just said no, because we don't know what happens a year, 5 or 10 years from now if we just try to rip out one piece of a large piece of concrete.
It could compromise the pool itself.
Well, that's their worry, and that's why they said we're not going to insure it. We're not going to guarantee the work. Like, if you want us to do something, we can, but it might damage it. Like, we have no clue.
So how do you feel about planters just in the back? Like,
I mean, we're open to greenery. We're not against it. As long as obviously you have to just do something that doesn't invade my neighbor's yard, because with the greenery that we have now kind of grows into our neighbor's yard where she cuts it.
These are just above ground planters that you would plant.
Yeah, I mean, we're totally open to any idea like that. And we do have like a planting area that we put there to put plants, so kind of continuation of that around the yard is not an issue.
Okay. It helps a little bit. Every bit helps.
Yeah, and I'm thinking, as far as I'm concerned, we can't really prescribe an area of planters because none of us have any expertise to know to what extent this is helpful or not.
No.
So I think my thinking, I don't know if we're leaning this way, but it's toward, letting this go, as it were, and asking Mr. Kaplanov if, out of respect to the environment, he would do something. We're not going to, we wouldn't impose it.
Yeah.
The city staff wouldn't monitor it.
No.
You wouldn't get a visit from the Property Standards Committee. But just recognizing that, needless to say, knowing what you know now, you probably would have got a permit for this.
Well, I would have probably just put stepping stones.
I'm not blaming you, but it always mystifies me that people in the business of building pools aren't aware, apparently not aware to advise their client, you need a permit, It mystifies me.
Well, we have that. That's what started this, is the enclosure. So we have a young kid. We're definitely not getting no fence. That's a dangerous thing.
Yeah, I get it. Okay, so what is your pleasure?
Again, there's not a lot of planting area there even for, I have one more question if I could. The existing deck, because I have no photos of that, is it wood?
I believe it's like cedar. It was built by the initial builder.
But it's wood, it's not a cement.
No, it's not cement. It's just wood.
And what's underneath the deck?
Like little stones as well. I think it's just ground.
So that ground is permeable.
Yeah, I just don't think it counts.
I know, yeah. But in reality,
yes, the rain goes through there. We can't use it for storage. Like we've learned pretty quickly, things get destroyed when it rains because it goes to the ground, as you said.
Okay, so I mean, I'm trying to think of some after the fact conditions that we can put in or recommendations, and I'm what I'm thinking. I guess I'm just discussing at this point, or is that the area to, I'm trying to see, what's the orientation? North is, okay, so that would be the, to the east side of the house be maintained as permeable, and that the area underneath the deck be maintained as permeable. In other words, you can't cement that at some point in the future.
Leave it permeable.
Yeah. I know what you're going to say. I know what you're going to say.
We're grasping at straws here.
Yeah, really.
Well, the question is, though, Phil.
Yeah. Of course.
Yeah.
Of course.
Yeah, I mean, that's why I'm not even gonna go there with the plan.
It's not
No,
enforceable.
it's not. It's not
So,
enforceable.
question, if we refuse it, then, but then will that not give him, I'm just thinking aloud here, because I don't, not to be nasty, but say we refuse it, then that gives him the opportunity to work with staff to come to a resolution on this. No?
I don't see the harm in putting in a condition. I know it's not enforceable, but in a way it is, because it's essentially it's an undertaking by the applicant and that, you know, they're aware of the situation.
So, we can spell it out so that it's very clear that the
Yeah.
area underneath the rear deck be maintained as gravel and permeable, and the deck be maintained as wood, so that he doesn't replace it one day.
Well, I wouldn't say wood, because I mean you can do a composite deck and still have permeability openings in it, right?
Work with permeable material.
Yeah.
Allow for permeable.
Allow for egress of water through the deck. Okay.
So that's the back, and how did you want to treat the sides?
The sides is it be maintained in a state with permeable pavers or some other material that's permeable. Yeah, perfect. So,
The bill was big enough for the pool. I don't need to do more work. We're here to just maintain it and keep steady state and pay those big energy bills now.
so subject to those conditions, I would move approval.
Thank you.
Would anybody care to second Mr. Komarik's motion?
I'm not going to add this as a condition, but just remember when you're replacing your asphalt.
I'm sorry. Leave? Oh,
When you're replacing your asphalt in the front, I'm just going to add this. It's not a condition, but when you do eventually get around to replacing your asphalt in the front, think about replacing it from the
understood. Sorry, you said I can leave. I don't know. All right. Thank you, everyone.
Oh, we haven't moved it.
No, we haven't.
It's been moved.
It's been moved.
There's
We
no one
haven't-
has seconded the motion.
So did I second the motion?
You thought about it, and then you kind of.
I thought, no, I mean.
This threw me off for a second.
I'm
The owner
listening.
was
I didn't
walking
hear.
away, thinking it was a done
Oh,
deal.
no, he
so
better be
I just wanted to add that when you're,
Yeah,
when
no,
you're
understood.
thinking about doing something in the front. Sorry, I wasn't, my mic wasn't on. That you.
Okay,
think
so
about that.
we now have a motion that's been seconded.
Yes, it is
Okay.
seconded.
All in favor? That is unanimous.
Thank you.
Enjoy your pool this summer.
Enjoy
Thank
your
you.
pool.
Have a good day.
Don't have a heart attack when you're swimming. Thinking about today. No, it's not. Okay. We can now move on to item number 17, which is it's coming. Purpose is to permit a landscaping deficiency. Oh, no, that's what I just did. Oh, my God, how could I forget? Yeah, I think so. There's 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. 17. Okay, this is 277 6th Street. It's hard to say. The purpose is to construct a new two-story rear yard addition and a new two-story rear addition above the existing dwelling and a new two-story laneway suite. There are 2 variances. This application was deferred on February 22nd, 24, to provide an opportunity to correctly identify the required variance. We have a Metrolinx advisory and a transportation services advisory regarding the need for a 1-meter lane widening along the easterly portion of the property to satisfy the requirement of a 6-meter wide lane right-of-way. The agent is Mashad Meshksar, and I don't believe we have any speakers in the room or at home.
That is correct, Mr. Chair, just the agent.
Okay.
Before we proceed, Mr. Chair, I'd like to ask a question of staff, or whoever can explain to me what variance 2 actually means. It's just really, no, but it's really confusing because it says a dwelling unit. I mean, according to this, a dwelling unit would not be permitted in a townhouse. But I mean, is a townhouse not a dwelling unit?
It's kind of weird, isn't it?
That's what I was thinking.
Between a townhouse and a row house.
They're the same. But we're talking about a second suite is not allowed in a townhouse, which that I understand, but like a dwelling unit is a dwelling unit.
You look like you can't live in a townhouse.
No, what I think it's clarifying is that that specific section of 569 refers to detached house, duplex, triplex, and fourplex, but not specifically a townhouse. Yeah, that's basically what it is.
It's not a permitted use in this zone, but it already exists. So is that then a legal nonconforming as opposed to it being a variance? Uh-huh. Because this is an older townhouse.
Which one is it?
But they're expanding it. When you expand a non-conforming, you have to.
Understood.
Yeah, then it becomes a variance, right?
But you're right, because it's being expanded. You're right. Okay, I got it. Just did it, yeah. Okay, got it.
Are we good? Is Mr. Meshksar available to speak to us? He's online.
Yes.
Hello.
Hello, Mr. Chair and committee members.
Yes, could you just repeat your name and give us your address and tell us about your proposal?
Yes, my name is Mahshad Meshksar and my address in 180 West Beaver Creek Road, Richmond Hill. I need to mention that our application is including 2 parts. One part is for the rear addition in the 2-story addition in rear yard, and the second part is lane-based suite. But we got the approval, the zoning approval for the lane-based suite, so our variances is just related to the addition part. The property in question is located in an RD zone. The proposal aim is improve the existing unit with a two-story rear addition and interior alteration. This application involves two variances. The first variances pertain to the existing condition of the building, as you mentioned that the dwelling unit in the RD zone is only permitted in a detached house, duplex, triplex, and fourplex. However, the existing dwelling unit is located in a townhouse. So this variance related to the existing situation of the building. And the second variance concern the floor space index. The permitted FSI is 0.4 times the area of the lot, while the proposal is 0.791. So it's important to note that if you check the survey or site plan, the rear addition is aligned with the neighboring building on one side and in the recess compared to the neighboring building in other side. So the rear building facade is aligned or even recessed compared to the adjacent buildings. Furthermore, many neighbors on the same street have developed their properties in a similar manner, exceeding the permitted FSI. These examples have contributed positively to the community by enhancing property value and providing better living space with positive impact on the neighborhood character. Overall, the proposed development respects the characteristics of the neighborhood while aligning with the general intent of the related zoning bylaw. Thank you for all considering our application, and I'd be happy to answer any question.
Okay, panel, any questions of the agent?
Yeah, I have a couple, if I may.
Yep.
Is there a basement on this, on the main house?
No, there is no basement.
There's no basement. Okay, that explains my confusion on the drawings. Okay. And the FSI that you're requesting, do you have other examples of that FSI in that area?
In another neighborhood, I got many pictures from the neighborhood building that had addition in rear yard, and with the similar condition with the subject property. And I talked to the planner as well, because the planner had some comments for us, and in the previous committee we asked for deferral because of the planner comments, and the planner told us that yes, there are some addition in the same neighbor with the FSI, and he told me the FSI number even, but unfortunately I forgot.
No,
and he asked me to keep the addition, the area of the addition in the FSI near to 0.79. That I did it because it was the similar to the another sample of addition with the exceeding FSI.
Okay, and just a comment. I mean, I can see from your survey that what you're proposing does line up with the neighbors. It's helpful to us if you show that on your site plan, if you show the neighboring, just the outline of the neighboring properties on your site plan.
Yes. In my design, maybe I didn't show it in a site plan, but in my design, consider it the rear lot line for the addition to align with the adjacent neighbor.
No, I understand that.
Exactly the same.
I'm just making the comment. Thanks.
And ma'am, do you understand, are you okay with the transportation services? They're advising us that a 1 meter lane widening is required along the easterly portion of the property?
Yes,
are you aware of that?
For the laneway suite. Yes, we did it. We did it for
you've
the
already done it.
laneway suite proposal. But this variance, but we got the zoning approval for the laneway suite, and we exactly did this 1 meter distance between the lane and the laneway suite.
Yeah, okay. Again, it's just an advisory. It's not a condition, but I just wanted to make sure you're aware of it. And you are. Thank you. Any other questions for Ms. Meshk? Sorry.
Yeah, so with regards to the laneway suite, you indicated you've got separate approvals for that now?
No, I think it's zoning compliant.
Completely? Okay, so then we should remove that from the notice. Okay.
Well, I
Yes,
think
our application was including both laneway suite and addition. That's why both together in this application, but we got the zoning approval for the laneway suite. So
yeah, yeah.
Okay, thank you. We'll take it up from the reference. Yep.
Okay, and there's no one in the room to speak to. I know why you're here. Sir, are you here by any chance to speak to this item here?
Yes. No.
No, you're good?
Something else.
Okay.
Item number 19, Mr. Chair,
19,
he's
all
for.
right, I'll
Yeah.
remember that. So, no more questions? So we're ready for a motion.
I'll move a motion to approve. I believe the application meets the 4 tests, subject to the conditions in transportation memo. Oh, that was just advisory.
No conditions.
Sorry, yes. Sorry.
It's
There
just
are
an
no
advisory
conditions.
comment.
I'll second that motion.
Okay, motion's been made and seconded. All in favor? That is approved unanimously. Thank you, Mashad.
thank you so much.
Yeah, thank you.
Thank you so much. Thank you.
Okay, so we're moving on to item 18, 33 Flindon Road. The purpose is to construct a new duplex with an attached garage. There are 9 variances. This application was deferred on February 8th, 2024 to provide an opportunity for revised plans and a revised zoning review. There are 2 transportation conditions, 1 planning condition, 1 letter of opposition. And is there anybody on WebEx that wants to speak to this?
Yes, Mr. Chair, we have 3 area residents that are present, all virtual.
Ah, yes. Floria, Chiapetta, and Farina. Correct?
Correct.
And the agent is Eddie Perez. Eddie.
Hello,
Perez.
good afternoon, Chairman and
Good
committee
afternoon.
members. My name is Eddie Perez. I'm at 537 Rogers Road for designers for this project, EKP Designs. As you see, we're proposing a duplex that was deferred prior to deal with planning, and we went with planning with a new design for the roof layout. The only variance we have now for the height is only in the front because of the dormers. You only allow 25% dormers, and we have a little bit more. At the back, we comply because we put 2 dormers, but just for the look of the house, it looks a lot nicer with the way we did the dormers. If we put 2, it would look odd compared to the way we did the front and the second and the first floor. And as per the planning department, they're okay with it. All they did is ask us to remove 1 dormer in the front, and we did so, and that's the condition that they have. We have a few variances were approved prior. The side yard variances that were approved prior on the other application, we maintained both of them. And now if you put up the site plan, we have a front yard setback, but on the neighbor side where they're opposing it, we have more than 7 meters over there. It goes on an angle, the driveway. The driveway, the front yard on the opposite side, those neighbors they gave us a letter of support. So we only have opposition on the other one where we have a greater side yard. And if you look at the neighbor's house, the footprint is a lot bigger than ours. Our house is only 12.64 meters high. We do comply with the main height, like the underside of the soffit height. The only one we don't comply with is in the front. But like I said, that one we could make it comply, but the house wouldn't look nice. So that's why we're asking for the one only in the front, and that doesn't give any impact to the neighbors whatsoever. And as you can see, we comply with the green at the front and at the back. So I feel that the application before you today is a good application, and it meets the 4 tests. Feel free to answer any questions. Thank you.
Any questions for Mr. Perez, panel? No? Okay. Let's move on to our registered speakers then. We have is it Ian Floria or?
Yes, good afternoon. My name is Ian Floria, and I'm the owner of 33 Flinton.
Ian Florian, before you go any
now.
farther, I do have a quick question.
Yes,
You
sir.
have noted that you want to be on video for this. Is that still the case?
No, it's okay. I can, if this works for the panel, this is just fine with me.
Understood.
Yeah, that's fine. Thank you.
Go for your presentation then.
Yes, sir. Thank you. So if there are any questions, I'm here. Of course, I'm the owner. I wasn't able to be in Canada because I have an emergency issue here in Europe, so I had to leave about 5 days ago. So basically, if there's any questions that I need to answer, please feel free to ask me. There's nothing more that I can say. My intent to build this house is for myself and for my parents.
You've already hired an agent who's spoken to us, sir. We don't.
Yes.
Thanks for the
yes,
opportunity to ask you questions, but we're dealing with your registered agent. You selected him. He's our contact point.
Sorry,
Okay.
Mr. Chair, our list doesn't have him as the owner. So
There's the confusion, but he's now
Yeah.
confessed that he is the owner, and he's hired an agent.
Perfect. Thank you, Mr. Chair. We'll go on to the next.
Sorry to
case.
play hardball, but we haven't got time to talk to everybody. Okay, so now we have two people that aren't owners, I presume. Ben Chiappetta would be the next on the list. Mr. Chiappetta?
Can you hear me?
Yes,
Can
hello.
you hear me?
Yes, we can. Could you give us your name and address and
Yeah.
tell us
first
what
name
you
is
want to
Ben,
say about this project?
Yeah, first name is Ben, last name is Chiappetta. I live at 35 Flindon Road. I'm on the west side of the applicant's property.
Sorry, we can barely hear you.
Okay.
That's better.
I'll turn up the volume. Sorry. This has been an ongoing situation in our community. There's been multiple owners of this land. It used to be one property and then they severed it. And just recently they sold it and they have this applicant. The first house has been built. There was no problems because they stuck to the original plan. So there was no issues in it. The second one, which we're here to discuss, changed it completely from the original plan. That's why I'm opposing it.
You're opposed because
That's
it's
it.
changed?
Yeah, exactly.
Hi.
So
this is Andrea
what
Chiappetta.
about the changes don't you like? What
Hi, this is Andrea
what problems
Chiappetta.
do you have with the
I'm speaking
variances that
from-
we're looking at here today?
Yeah, this is Andrea Chiappetta speaking on behalf of my father. My father suffers from Parkinson's.
Mr. Chair, I did mute the agent there real quick, or the speaker, just because I noticed we're jumping onto someone else started speaking out of nowhere. Do we want to, we'll have to have that person identify themselves properly here? Yeah, sounds like it for a second there.
Yes, this is Andrea Chiappetta, 35 Flindon Road. I'm the son of Ben Chiappetta. My father suffers from Parkinson's disease and is currently
Okay.
experiencing a flare-up of his disability. So
Mhm.
if the chair would allow me to continue, if that would be at all possible for the remainder
Sure.
of the time.
Yeah, no problem.
Yes. So, yeah. So the reasoning for the opposition to the proposed application at 33 Flindon is that the applicant was in possession of the original plans, which was built at 31 Flindon and 33 when the land was severed, and chose not to complete those approved plans by the Committee of Adjustments, and has gone forward now with these new plans. The new plans go against the character of the neighborhood with a duplex. There is no duplex in this community at all. It is a proposed 3-story, if I'm not mistaken. I apologize if I am mistaken. I'm not familiar with the application myself, but from what I understand, it would encroach quite drastically on the neighborhood and how it is designed, as well as its height against our property next door at 35 Flindon. So the number of variances that have been proposed in terms of its size and its being a duplex do not align with the neighborhood at all. It would not fit the character of the neighborhood. Many others in the neighborhood have tried to place other properties similar to this and have been opposed. And I also believe that this property should be opposed, and a single family dwelling would be more suitable for the neighborhood and its character.
Well, that's really irrelevant as of the last little while. Duplexes, triplexes, fourplexes are permitted in every residential zone throughout the city of Toronto. So the fact that it's a duplex isn't something that we're going to consider as offensive. It's really the development standards that are set out in these variance requests that we're concerned about. So you've got to tell us if you've got problems with front yard setback, rear yard setback, side yard, wall heights, whatever. The list of 9 items, that's what we're asking for your comments on. But duplex, out of bounds, not an issue. It is to you, but it's not as a policy matter. It's a permitted, it's a permitted use.
Yeah, so we do oppose all 9 of the variances in terms of its of what has been proposed, and would feel much better if the units or the application itself abided by the bylaws that are required under the City of Toronto.
So you can't, you don't like any of the variances. So variance number 4, for example, you don't like 1.5 meters, but you're okay with 1.8. Is that right? Tell us why you don't like
yes,
those
that's correct.
that quarter of a meter, not 9 less inches. Why is that a problem for you?
Simply
Sorry,
because,
I'm not trying to be difficult here, but it's important for us to understand specifically from you what problems you have with any of these 9 variances. When you say I don't like all 9, I'm sorry, I'm not accepting that. You need to tell me what problems you have. Why any of these things have a negative impact on you? I need to hear that.
Yeah, I understand that, and like I said, I just into the room because of my father's disability. Simply because that they would start encroaching on the front of our yard, making it much more difficult for us to exit our house. It would it would encroach on the sunlight that is entering into the unit. Most of our windows are westward facing the property in this application. So that would diminish the sunlight that is entering the home. There is a fence that we own on the property line that would also be potentially damaged and or destroyed through this construction if the variances aren't followed through the bylaws, and could result in further damage to our property, which has happened in the past with previous owners of the same property.
Okay, thank you. Any questions for Mr. Chiapetta? No? Okay, so we also have Sandra Farina available. Sandra?
Yes, hello.
Hi.
My name is Sandra Farina, and I live across from the applicant's property. I live at 1 Flaxman Road, so I'm at the corner.
Oh yeah, okay.
And I'm here on behalf. I am here on behalf of some of the residents, including myself, on Flindon, Flaxman, Jasmine, Acacia, and Lilac Avenue, that are all kind of affected by the traffic and whatnot that I'm about to speak upon.
Okay.
We have a lot of seniors in our community and children. Upon reviewing the application for minor variance, the residents, including Mr. Chipetta, are very concerned. For Mr. Chipetta directly, I can add to the stress and the issues that it's dealing with. Their home is in very close proximity, and their daylight is and will be fully blocked, because now it's not only the one home that's further to the east, but also the new one being constructed so very close to the lot line. The second issue, as his son Andrea tried to express, is also the issue with the driveway. Our community on Flindon and the other streets that I mentioned prior have been part of the elementary school bus route for well over 36 years. Now, having witnessed all the ongoing issues with the bus drivers not being able to see properly because people park on both sides of the street, and with people renting out their basements or having an increase in students all of a sudden that are renting rooms, we have additional cars that are parked on the street. Police cannot come every night to enforce no on-street parking right through the winter and everything. So it creates additional visibility issues, not only for the buses, but also us as residents. There's not one day that I try to leave my driveway or try to pull back in my driveway at night that I do not have to be forced to drive on top of the curbs, because I just can't make the turning radius into my own driveway. Now, it's not only this property, like I mentioned, there are other properties, but this one is even worse because the setback from the garage, any two-family home, now it's a duplex, which to me requires at least 2, 3, 4 cars. An average family is 2 cars nowadays because not everything is accessible to transit, but we are concerned it will add additional space, additional vehicle traffic onto our roads. And we also have, currently, we have 3 seniors and 2 disabled children that get walked daily by their caregivers and have to do these little hurdles in between cars every day. And our streets are also being used shortcuts to get to Highway 401. So we're right north of the highway. So everybody's using our side streets, which have no sidewalks. Okay, and that's another concern of mine particularly, is with the setback that is being proposed. That is going to be the side that the city would consider putting a sidewalk, because I've been lobbying for a sidewalk in our community for quite some time, and because of funding and this and that. But now our schools are over capacity. We can't get bus routes because we're too close to the schools. So our children are forced to walk on the streets, and that's a big concern. So again, the sidewalk, the proximity and the blockage to Mr. Chipetta's driveway and his family and his children. When they're reversing, I experience it myself. If there's cars parked on the street, I have a pickup truck. If I don't back in, if I'm not able to back in my vehicle at night, I cannot pull out of my driveway, because it's a safety issue. I have to drive over my curbs and the city curbs, okay, every single day. So this is a growing concern for our pocket, for the safety of the children, our seniors that walk to the bus stop, be it with their walkers or their canes, and the flying cars that, has nothing to do with this committee, but is a growing concern for us as a community as a whole. So I kindly ask that this committee take
Okay, ma'am, your,
extra
your-
consideration.
ma'am, your presentation time is ending in 4 seconds. If you could wrap up?
Thank you. Yes,
Okay.
I just asked this committee to please take this into account for consideration, and the impact that this has in the abutting residents especially, and that road that has no sidewalks and is a bus route.
Okay, thank you.
I thank you for your time. Thank you.
Thank you. Panel, any questions for Ms. Farina? Mr. Perez, it's time for your rebuttal opportunity.
Yeah, hello again, committee members. I was listening to what the neighbors have to say. We were very sensitive when we were designing it. We try to meet the main height of the roof, which is we're under. The main underside of the soffit, it's only on the front, as I said earlier. And we were also sensitive to the way the street's sculpture is, that we actually put an integral garage, so there'll be parking inside the garage, and then there'll also be a spot in front. So we did take that into consideration. And as you know, for the new duplexes and such, don't even need have an integral garage. But we saw the way there was no curves and sidewalks there, so we added the integral garage to our design. And if you look at the pictures and all that I've sent, there are many homes in that area with the same type of design and the same type of roof lines and all that. If you can put the pictures up, of the pictures I sent in, you can see what I'm trying to point out. If you can put those pictures up, you can see there's a lot of if you keep going forward, I put some addresses there. They're all 3 stories high. And it's very common in the area, and it meets the 4 tests in the character of the area as well. And also with planning, changing the roof lines and that's why they're on board and they're okay with our application. We worked very hard with them as well. Thank you very much.
Okay, thank you. Panel, any questions for Mr. Perez?
I have a few.
Yep.
Just prior to the severance, was there a garage that was right next to number 35? Eddie, you may not.
Yeah, it was an old frame garage.
And do you know what
It
the
was an old
setback?
frame
Do
garage.
you know what the setback was on that garage? The side
No,
yard setback.
At the survey there, I couldn't tell you. I just know
But
from seeing it on Google.
I'll tell you what, I
because
don't really know what,
the
I don't
survey-
really care what it was, but I'm assuming what you're building now is better than what that garage was? Is that
Oh
fair?
yeah, way better. The other one, a huge frame garage before, very big.
So that garage
Now
was
it's just a
closer,
single-
was closer to their house than what you're proposing now? Yes?
That's correct.
Okay, I just wanted to clarify.
Yeah, yeah.
Okay.
Yeah.
In their letter, they expressed some concerns around privacy issues. I'm assuming you would not be opposed to putting in a privacy screen on the west side of your deck?
No, we have no problem with that.
Okay. I'll go back to them and ask if we can get them back up to see if they'd, what they would think of that. Just curious. Can we get, I don't know, the son, I guess, since the other one wasn't available. So it's from number 35?
Yeah, that's Chiapetta?
Chiapetta? Okay.
Would the
Yes, that's fine.
Hello? Would you?
Yes, that's fine.
Okay, thanks very much.
Good.
What else was there? Transportation conditions, planning. That's the 2, okay. I'm just trying to see if I had other questions. I think I don't. No, that's it. Okay, thank you, Eddie.
Okay, any other questions?
You're welcome. Thank you.
No? Okay, are we ready to go into committee for a decision then? Okay.
Well, since I've already been talking, I'll keep going. I don't have a problem with the setback issue. It's very obvious that this house is being situated perfectly between the other 2. It's set back from further than number 35. There's obviously no obstruction issues with that. The privacy issue, I think we can address. The applicants agreed to address that. Planning has a condition of approval. I'm assuming the applicant's okay with that. So I believe this application yeah, I got those two of them, I know. Yeah. I'm not doing the motion yet, so I'm just, I will get to that.
He's just talking.
I'm just talking. Yeah, we got time to kill. No. I just wanted to give some background from where I'm coming from for the motion. I believe this is good planning. I believe it's the kind of intensification that we want to see in the lot splitting that's been occurring. This, I think, is much more favorable than some of the earlier applications we looked at today. So for that reason, I believe it meets the 4 tests. I would like to move approval, subject to the planning condition, subject to the 2 transportation conditions, and subject to a privacy screen being constructed on the west side of the rear deck. 1.5 meters in height. Thank you.
Thank you, Mr. Kamork. Is there
I
a
can
second?
I can second that, but I just wanted to add that I think this is an improvement over the existing condition, and the neighbors really should, I think, embrace this. So that's just my comment.
Okay. Motion's made and seconded. All in favor? That's unanimously approved. Thank you, Mr. Perez. Okay, we ready? Item number 19, 1180 the Queensway.
Yes.
We'll call you in a second. Are you Mr. Goldman?
Ivan Bubanovic.
Oh, you're from 1184.
Yes.
Your time's coming up. Sure. How's that? You good?
Very good.
Okay, number 19, 1180 the Queensway. This application is for to make interior alterations to convert the existing second-story residential use into commercial use. The altered building will operate as a commercial use only. There are 2 variances, one related to, actually both related to parking spaces. There are 3 variances, all related to parking spaces. Transportation Services is okay with this application. Community Planning has requested 2 conditions for approval. We have a support petition, and this matter was deferred on April 25th, 2024 to provide an opportunity to correct the required variances and a new notice to be circulated. The agent is Barry Goldman. Mr. Goldman?
Good afternoon, Chair, members of the committee. My name is Barry Goldman. My address is 321 Carlaw Avenue, Suite 203.
Okay.
I'm happy to make a short presentation if you like.
Yeah, maybe make a short one. I'm only thinking this is pretty straightforward, but we do have somebody that wants to, Mr. Bubanovic is here to speak about your project, so maybe it would be helpful to him and us if you had a few words to say about the project.
Certainly, I will be brief.
Okay.
So as you noted, Chair, the proposal is to repurpose an existing building and remove the residential component from the second floor, convert that to dining. That did create the parking variances, which I'll note are existing conditions on the site. The site has supported commercial use for decades, and if transportation and planning are all right with it, I think that's a reasonable indication that this is appropriate and passes the 4 tests. I think in the interest of brevity, I think I'll just let the other guy speak and then I'll rebut unless you have questions for me now.
Yeah, well, I got one. Maybe I'll open it up to the panel, but you're familiar with and okay with the 2 planning conditions?
Oh, yes, forgive me. I should have said that immediately.
No,
yeah,
that's okay.
I'm aware of all the planning. Yeah, we're aware of the planning conditions and we're happy to abide by them.
Okay, good. Panel, any questions of Mr. Goldman before we go on? Okay. Mr. Bubanovich. Tell me whether you're Paul or Ivan.
My name is Ivan Bubanovich. I live on 2288 Nina Crescent in Oakville.
Okay. And could you tell us what you think about this proposal to convert?
What I think here, this is just not good. See, the thing is that we have no parking spots in the streets on around the Queensway. Queensway, there is no parking, period. And they just keeping, and the street plaza that they have 14 stores, they have constantly their own cars in a parking lot. And this also that they're looking for additional parking. I don't know where they're going to put their back lane of this property, their what do you call it, disposal boxes. There is no parking there. There is no parking because there is a hydrant on the side of the building. And there is also exit from the plaza to the Brownlee Avenue. And on Brownlee Avenue, there is every 20 feet, there are no parking signs. So before last X number of years, when they approved that main store for the takeout, people, they come in and they just keep driving into my parking lot. They're disturbing. I have a problem with the tenants. They constantly complain. And also the dinner time and the lunch time, there is no parking anywhere around. The buildings across the street, they built these commercial, what we call it, high-rise buildings. There are also people from there, they just keep forcing the issue to park on my property. And I have tenants which they're very, very upset, and constantly there is a problem with that. See, if they people build another 30, 40 seats restaurant on the second floor, you're talking 40 seats. In the 40 seats, if the people come to lunch, if you put 4 people in a car, they need 10 parkings. And there is no parking now at all. On Brownlee Avenue, on the front of these Italian small houses, there is on the front of their property, there is a sign, no parking. And there is no parking in any other streets, and no parking on a Queensway. It's really getting bad. Mm-hmm. So this is because you can't just sit outside with a sign or chase people away. It's no good. You don't know who's coming to the street or what is going to park or how long he's going to stay. They're just blocking my parking lot at lunchtime and dinner time. And my tenants are really upset. They're furious lately. And now we got to just add more restaurant or takeout service because there is in a plaza, street plaza, 14 stores. And each that store, they're sitting 2 cars. And there is no additional parking in that plaza. So as soon as they come around the corner, just pull on my property.
Okay.
So what is your property?
We have Mr. Bubanovich on.
1184 the Queensway.
Okay, that's what I thought. So you've got the big parking lot in the back.
Yeah, yeah, that's right.
Okay. Any questions for Mr. Bubanovich? Okay, you can have a seat, sir, and we'll invite Mr. Goldman to address your concerns.
Thank you.
Thank you. Mr. Goldman. Mr. Goldman?
Hello, can you hear me?
Yeah, Mr. Goldman?
Yes, can you hear me?
Yes, I can hear you.
Hello?
Did you hear Mr. Buvanovich's comments?
Yes, I did.
Okay.
I do sympathize. He owns a restaurant more or less next door, and it seems to me as though he's trying to prevent the competition from opening up next to him. I understand people park in his parking lot, and the answer would be to put no parking signs in the lot. The variances we're seeking here don't pertain to his property or people misusing his property. The city is becoming more dense as time goes by. I'll note there's a new condo across the street. I expect within 10 years there'll be a lot more. People are well able to walk or take transit. And the demand for more places to eat is going to keep going up. I don't believe this is going to particularly harm his business. But the idea that we shouldn't be allowed to create a restaurant because people are parking in his lot, I don't think is reasonable.
Panel, any questions for Mr. Goldman?
I have a couple, if I may, Mr. Chair. So is the restaurant use changing or is it staying the same?
The restaurant was a Burrito Boys when
Right.
the owners that I'm working for took over, and it was a ground floor burrito takeout restaurant. Initially, we started a permit set to maintain the residential use, and it was going to be a takeout pizza restaurant. The tenants decided to leave, and the owners pivoted to put a dining on the second floor to expand their business.
So it's not a burrito place anymore? Or it won't
No, it's going to be a north of Brooklyn pizzeria.
Okay, no, just curious. In terms of public parking, I note that there is a green pea lot that's theoretically within a 3-minute walk on, what is it called, Woolgar Avenue? Are you aware of that?
Yes, there are places to park, and I'd suggest, you know, the neighbor is correct. There's not a lot of street parking there, but I think that's just going to change the pattern. That, you know, there's enough people living within a 1,000-meter radius of this restaurant that could easily walk there. I don't think the lack of parking is going to be a significant issue. Just the condo across the street would almost be enough to support that restaurant, I would suggest. There's a lot of places within 1,000 meters where one could park.
Okay, and the reason I asked is whether the use is changing is so it's not like existing customers that are necessarily going to come back. This is going to be a new situation.
This is a new situation. It was a burrito takeout place, and we're proposing a sit-down dining on the second floor.
So this isn't just take from the counter and walk upstairs. This is like table service?
This will be, table service on the second floor as well as takeout on the ground.
Okay, so theoretically it is a more...
No, the maximum seating load, the second floor seating is not that big. It's going to accommodate less than 30 people.
No, understood, but it is a more intensive use than just a walkout, takeout place.
Correct, yes.
So there is an intensification, and theoretically it will generate more of a parking demand because of that change of use.
I think it's reasonable to suggest that's true. And I'd just say the arbiter of when you've got too much demand for parking would be transportation services, not an adjacent restaurant.
No, I understand that. I'm just
biased.
trying to clarify for the committee's sake what is actually happening here. So I get it. Thank you.
Any other questions? Okay, there being none, I think we can now move into committee for discussion if you require, or a decision.
I'm happy to try and make that motion.
Sure.
So we have revised plans and revised zoning waivers, so the approval would take that into consideration. So I'm going to move for approval of the revised plans, subject to community planning's conditions. And it looks like transportation is okay. And I think that's it. Just the community planning conditions. So I move for approval subject to those conditions.
Okay, thank you, Ms. Alderson. Is there a seconder for Ms. Alderson's motion? Mr. Dalton, thank you very much. All in favor? The application is approved unanimously. Thank you, Mr. Goldman. Thank you, Mr. Bubanovich. So our final item for the day is item 20, 27 Cronin Drive. This is an application for consent and 2 minor variance applications, 1 for each of the proposed parts. This application was deferred on April 25th to provide for proper notice. We have urban forestry condition 3, engineering and construction services and transportation services conditions, 1 letter of opposition, and planning advised of concerns with the front yard setback, front porch encroachments, bay window encroachments, and they recommend refusal of those variances related to those 3 things: front yard setback, front porch encroachment, and bay window encroachment. So I don't know what variances they would be exactly, but anyway, Mr. Eagleman, as agent, please present your situation.
Yes, good afternoon, Mr. Chair, committee members, and staff. Thank you for having me. David Eagleman, 900 the East Mall Suite 300, a planner here on behalf of the owners. So through you, Mr. Chair, I will provide a brief presentation. I did provide a detailed planning justification letter, but I will speak to the concerns raised by planning staff as well as some of the neighbors. And as you mentioned, Mr. Chair, this was deferred from the April 25th committee hearing. As you all may remember, there was a notice issue that has now been rectified, so we are back in front of you today. So I will note that I have reviewed the memos from both urban forestry and engineering and construction services and have noted that they express no concerns or objections, and we are agreeable to both of their recommended conditions regarding this application. We have also consulted with adjacent and surrounding neighbors regarding this proposal and have obtained 13 signatures in support, including the immediately adjacent neighbor at 10 Friendly Drive, as well as the neighbor immediately to the rear at 78 Laurel Avenue. We have also consulted extensively with planning staff regarding this application and have made a number of revisions previously in an attempt to satisfy planning staff. So some of those revisions, which apply to both new duplexes, include eliminating the maximum overall height variance, eliminating the main wall height variance, eliminating the building length variance, among other revisions as well. And as per their report, they are still not satisfied with the proposal. They did raise concerns with just the front yard setbacks proposed, as well as the front porch encroachment variances and the front bay window encroachment variances, which are all related to the front yard setback variances. Yep. So I would like to ask staff to please pull up the location map, and as staff are pulling that up, you will see on the location map, if we can zoom in there if possible, you'll see that 27 Cronin Drive is located at a portion of Cronin Drive where the street right in front of the subject property makes a 90-degree turn to the west and then 90 degrees again and proceeds northward. So because of that, you can see that houses north of the subject property are significantly farther west in front of the existing dwelling on the subject property and existing dwellings south of the subject property on Cronin Drive. And so dwellings north of the subject property are much further forward. And if I can please ask staff to also pull up photo number 2 of the submitted photo study. You'll see again in this photo that shows that 10 Friendly Drive, which is the immediately adjacent dwelling to the north, is significantly farther in front of the existing dwelling on the subject property. So the proposed front yard setbacks, although they're a reduction from the requirement, they do provide a transition from the dwellings south of the subject property to the dwellings north of the subject property. So you can see there in photo number 2, a 10 Friendly Drive is significantly farther forward. So the reduced front yard setback provides that transition from dwellings south to dwellings north. And on top of that, it is a reduction of only 1.87 meters. in the case of the smaller front yard setback on part 1. And the longer of the proposed new dwelling, which is at part 1, is only 13.41 meters in length, which is 3.59 meters shorter than the permitted building length. And both dwellings have a rear yard setback of 13.79 meters, which is 5.21 meters larger than the minimum required rear yard setback. And I'll note too that although we don't have a signature of support from the adjacent neighbor to the south, which would be at 25 Cronin Drive, the owner did consult with that neighbor and actually preferred the dwellings to be farther forward rather than further to the rear. And in addition to that, the neighbor at 80 Laurel Avenue, who actually raised concerns with this, has concerns with privacy in his backyard because their backyard actually sort of aligns with and extends to the backyard of the subject property. So we're actually improving privacy conditions by moving the dwellings further away from their rear yard. So those are my comments. It is my professional opinion that the severance ultimately meets the consent criteria in section 5124 of the Planning Act, and that the minor variances meet the 4 tests in section 45.1 of the Planning Act. Happy to answer any questions.
I'll just make a quick comment. It's nice to see variances related to a consent that don't include lot frontage and lot area. Anyway, any questions or comments for Mr. Eagleman? No, there's no one else to speak?
No, through Mr. Chair, there is no one else on this item to speak.
So if you're ready, we can move to...
I've got questions.
Your questions? Okay, go ahead.
And perhaps comments. I agree the severance is appropriate. My only concern is the front yard setback, and I don't agree with half of what you've said. You're differentiating the setback between part A and part B by 0.05 of a meter, which in my view is not discernible. So essentially they're both about the same, you're requesting the same setback for both of them. If you were trying to actually articulate this, then you would be setting one of them back further than the other, and then you'd have that articulation. That's not what you're doing. And it just doesn't line up with the rest of the street. You're not on the curve, you're before the curve. So why would you not set one back further than the other if that's your argument?
Through you, Mr. Chair. So again, I don't think I was trying to say that I know the front yard setbacks proposed are very similar between the two dwellings. And again, the owner did consult with the neighbor at 25 Cronin, and they preferred that we push the dwelling forward rather than move it back. So out of respect for that neighbor, we did not want to move the dwelling at part 2 further into the rear yard. And the dwellings are already much lower than the maximum permitted length. So if we were to increase that front yard setback, we would have to, without making the length greater, we would have to make the length much more smaller, the length of the dwelling. So, and we felt that this was an appropriate setback. Again, the dwellings north of the subject property are much further forward.
Yeah, but the road alignment is completely different north of the dwellings. So to me, that's irrelevant.
Through you, Mr. Chair, I would say from a functional perspective, despite the alignment of the road, when you're walking down Cronin Drive and you're standing in the front yard of the subject property, you see a dwelling that is almost entirely located in front of the existing dwelling on the subject property.
Absolutely, because it's past the curve. Of course.
The existing dwelling is past the curb, but the new dwelling will start actually on the curb. It's the old dwelling that's past the curb.
The old dwelling?
The existing dwelling is past the curb. You're right, it's past the curb, but the new...
No, there isn't. Well, I mean, to me, if you're going to articulate this, you would have, you would split the difference between number 25 and your, I don't know, which I guess would be part B. And then you'd have a pattern that complements the curve in the road. I guess what you're saying is the owner of 25 basically wanted no encroachment in the back.
Through you, Mr. Chair, that is correct. And I'll note too that if you just look at the site plan, even with the proposed front yard setback reduction, regardless of the dwellings to the north, it doesn't perceive as much of a really substantial difference to the existing dwelling at 25 Cronin when you're looking at the site plan.
I'm not sure I agree, but okay. Anyway, that's my concern and my comments.
Okay. I don't believe so.
Do you have any documentation from number 25 in support or otherwise?
Through you, Mr. Chair, we do not. My understanding from the owner who's here today in the room, he consulted personally with that owner. It is, my understanding is that's a very old woman. I think at this point, her health is not great, so we weren't able to obtain a support signature, but I've been told by the owner that he did discuss this specifically with her.
Well, it's like the application we had earlier. The evidence isn't here, so we can't consider it. Okay.
You prepared to make a motion or? No?
You know, the motion I'd be making would be denying variance 3 and approving all the rest, but I'm not sure if I want to go that route. I want to see how other people feel about this.
So you prefer a colleague to table something on this? Okay. Invite a mover and a seconder for.
I just want to comment, I can see why 25 does not want an additional setback on the house, because it means that her backyard will be impacted.
Yeah.
Except that this is to the north, so it's not going to really block sunlight if it's to the north of the property, right?
But she might not want to look at a wall.
Yeah, and it depends on how the discussion took place. You know, it's like, do you want it here or do you want it there?
Yeah.
The third choice is you make the house smaller. That probably wasn't offered to her as a choice. So we don't know because we have no evidence.
Yeah.
Not having any evidence, I can't consider what 25 allegedly wants or doesn't want.
Community planning seems to be okay.
Community planning is suggesting that the setback, they have concerns with the front setback and the encroachment, and that those should be refused. And that would mean refusing variances both 3 and 6. They didn't come out and say that. They're kind of doing it really.
Yeah, so it says, hey, this is for our information, and at the end they say we recommend refusal of the variances related to front yard setback, front porch encroachment.
Okay, so they do
and
have
bay window
concerns.
encroachment.
They have concerns without coming out and saying refuse.
Exactly.
Yeah, they did,
which is a refusal.
Which is a refusal.
which was a refusal.
So they say it still stands. Yeah.
Yeah.
They did.
But, you know, the front encroachment notwithstanding, I'd like to see this lot severed. That's the dilemma.
Oh, yeah.
Yeah, because they're not small lots.
No.
Not small
Oh,
lots.
no, it's a perfectly reasonable, it's almost what I would call a natural severance in terms of the resulting lot pattern. It fits better than what's there now.
I'm just trying to see.
It's just where you put the houses.
Yeah. So FSIs are, what, is it 400 square meters we're looking at? Just trying to see if I got the right notice. 27, so 400. Is that coverage?
33 to 34%.
Yeah, I don't have a problem with the coverage. Yeah, it's not a small house.
Yeah, while we're considering that, perhaps I can ask Mr. DST whether the mechanism exists to approve some but not all of the requested variances based on cross-referencing them with the planning staff's memo of April 15, 2024, which appears to address minor variance 3 and 6.
Yeah, and you know, I would almost be willing to approve that for one and not the other. Like, because then you'd have the staggered houses, which would follow the street pattern. I think they're out of pattern, and I understand planning's concern from that perspective.
So the report's not specific as to variance request numbers,
Yeah.
items, but the more significant one is item 3,
Yeah.
which is the front yard setback, and many of the elements identified. Yeah.
That's really the only one, variance 3.
Yeah, because if you don't grant variance 3, you can't get variance 6 anyway.
If you don't grant variance 3, you got to set the house back 8.3. Right?
Yep.
Mm-hmm. You're looking at proposals for houses that are essentially 4,300 square feet.
Mm-hmm.
These are not small.
Not small.
No, they're big.
They are duplexes, fair enough. But even if you split that in half, that's still reasonable size houses. I'm assuming you had discussions with planning to try to resolve this and you weren't able to come to any?
Yes, through you, Mr. Chair, we have had many discussions with planning, multiple, and made multiple revisions. And if I may as well, Member Komoric, I will note as well on that side, on the south side, the dwelling to the garage has a larger front yard setback of 6.76 meters, so it does increase. And I'll note too that this is all to the property line. There's a large portion of the boulevard to the curb as well. So these are large front yard setbacks, even despite the reduction.
Fair. I'm just trying to find it on Street View now. Sorry, I'm going to need a few minutes.
Take your time.
Perhaps while my colleague is looking into that, Mr. Agent, can you advise in your discussions with planning staff whether there was any discussion specifically to the issues raised in the letter of April, or the report April 15, 2024? You've indicated other adjustments that your client has made, but with respect to the notes in the planning memo.
Yes, through you, Mr. Chair, we did have specific discussions about the front yard setback and the variances that relate to that. We did look at revisions to those. We did make slight modifications to the front yard setbacks. There were minor increases to the front yard setbacks. However, again, we planning staff actually, to Member Komorik's point, actually recommended a similar point that Member Komorik raised about having the dwelling on the north side be okay at where it's at and then perhaps staggering it a little bit. But again, because of the owner's discussions with the neighbor at 25 Cronin Drive, we were reluctant to move the dwelling further back because that would upset the neighbor on the south side.
Looks like it might actually trigger some urban forestry variances too as well if you move the dwelling back. I'm looking at Google Earth right now. Seems to be some substantial trees in the backyard.
I don't think that'd be a showstopper.
No?
Hard to tell, but we don't know. We don't know. I mean, I feel like we're kind of doing the planner's job right now.
Yeah. Well, I feel there's a solution here, but it's not before us. So with that,
It's, what's the existing front yard setback of number 27? Is it 8.92? I see that dimension in the southwest corner.
Through you, Mr. Chair, that is the existing on the south side. On the north side, it's a little bit smaller at 8.84 meters. And the required front yard setback, through you, Mr. Chair, is just the front yard setback of the dwelling to the south at 8.3. Because technically the dwelling to the north is on a different street, because where the street turns, it becomes Friendly Drive, and then when it goes back northward, it becomes Cronin Drive again.
What are comparable setbacks along the rest of that street?
I will get that for you, through you, Mr. Chair.
Well, 25 is 8.4.
8.4 at 25.
And we can probably look at the location map and take a reasonable guess. And Mr. Eagleman, why is this extra meter and a half so critical? Why couldn't you just go with the zoning prescribed frontage?
It's a fair point, Mr. Chair. I think through you, I think the intent is really just, again, to achieve what the client is looking for, and also they were being cognizant of consultations with the neighbors. And from what I understand and what the owner has advised me, who again is here today, he discussed this with the neighbor to the south, and they did not want the dwelling moved further back. And
Well, that's fine, but I'm just saying that's fine. Leave that and reduce the frontage by 1.5 meters. Make the house not as deep. Make it a 300 square foot house instead of 4,000.
Through you, Mr. Chair, just in that respect, again, the dwellings are already much lower than the maximum permitted length. So squeezing them even into a smaller length becomes really undesirable.
To believe that all of this is to try to accommodate the wishes of the owner of 25.
Through you, Mr. Chair, I think if it was absolutely necessary and I can discuss this with the owner who's here, but I believe if it was absolutely necessary for the committee to make an approval decision on this, I think we would be amenable to an increased front yard setback for part 2. We do have quite a large rear yard setback, so I think to the Deputy Secretary Treasurer's point, I don't think we'll have much of an issue with triggering other variances. So it's perhaps an option, but ideally we would like to.
I mean, you realize too, Mr. Eagleman, that even if we were to approve this as you've presented it to us, planning still has the option to appeal it.
Understood through you, Mr. Chair.
Which is why we're trying to come to some, reasonable conclusion where you actually do wind up with something you can go forward with.
Yes, through you, Mr. Chair, that would. So it could cause some complications potentially.
Because it's the domino.
You-
A, you're going to hit B, you're going to hit C.
Yeah,
It's going to affect coverage too, correct?
I mean, your other option is to, at this point, ask for a deferral.
Through you, Mr. Chair, that I think we would be very reluctant to do that. We've already deferred, and even prior to the previous deferral, we spent a lot of time, as you know, severance applications have to go through pre-circulation, and they don't get scheduled until either everyone is satisfied or we decide we want to proceed with staff not being satisfied. And so there were a lot of discussions in the process prior to even getting scheduled for a hearing. So even the last hearing, we waited quite a while to get to that point. I think a deferral at this point would be...
I hear you. Mr. Secretary Treasurer, I'm assuming we can't approve the severance and defer the variances.
There are separate applications. You can do what you wish, but we prefer to keep things
Together, yeah.
Yeah.
so that they're related to each other as we follow along. We would recommend.
Yeah, we hear you.
Okay.
Through you, Mr. Chair, if I may just add one last comment, that I understand planning staff have concerns. However, the only two neighbors that have raised concerns with this proposal have not mentioned the front yard setback at all. So no one has raised any concerns with the front yard setback. And in fact, a number of the neighbors in support, the 13 signatures we obtained, a number of them are located on Cronin Drive itself.
Yeah, I think your opposition is really to the duplexes, not to the land, to the form.
There's only one opposition left.
I have a question. So 10 Cronin, which is around the bend on the next part of Cronin, part of that building, that structure, looks like it's fairly close to the sidewalk right of way and the road. It is set back from the street quite a bit, but because it's in the curve, it actually sits forward. I'm just looking at that now. So if you go to number 10 Cronin, you'll see it's in the curve, but it actually sits fairly far forward on that curve. And I'm wondering if that means that the new structures, the two new structures, will be more in keeping with that to kind of carry that line through. I don't know.
Just trying to look at
Through you, Mr. Chair, that's actually 10 Friendly Drive. That's what that's the photo I was showing and what I was referring to in my presentation.
Really? Because it's okay.
It's Friendly Drive is effectively the bend of Cronin Drive.
Right. I see what you mean. Okay. It looks like there's two entrances. It looks like, well, actually, no. There's just one entrance, and it's on Friendly. But yes, it's close, much closer to the street.
And through you, Mr. Chair, that was really why we felt the front yard setbacks were appropriate again.
Yeah, I see why you might think that now.
Yeah.
You see that now?
Yes.
This is very, I wonder what the setback is on this particular property. Do we have that information?
Number 10?
Yeah.
I'll bet it's 6 something.
Even though the driveway is on Cronin.
Well, the driveway's on.
It's on.
Yeah, Cronin because of the width.
Yeah.
I wish they hadn't laid the streets out this way.
But that house is fairly close to the sidewalk. And the sidewalk promptly ends just after that property.
And through you, Mr. Chair, on the survey, there is a setback provided to the corner of 10 Friendly Drive to where the street bends, and that's 5.82 meters. But that wouldn't be the dimension from the front of the dwelling to Cronin Drive. It's sort of, it's shown on the survey.
Yeah, so part one, almost, the curve starts right at part one. All the more reason why I think it would make sense to articulate these two. Okay, I don't think I can split hairs on this one, so.
You can't.
Are we ready for motion?
Well, yeah, we got to make a decision on this. So.
There's one motion that we can make, but that's why I'm asking. Your other option is to defer. Because you're not going to like a motion.
You're the last item, so if you want to go and have a chat, go and have a chat. Sorry, I shouldn't be making that statement.
You can say whatever you want. You were the chair as of 5 o'clock.
Well, not for 2 weeks, my friend.
Okay. Because we can't split it. You can't split it.
Yeah, but you see where I see exactly where this came from now, because this house.
Yeah, but what I think
is so close to the.
But what? Yeah, but what?
Yeah, and there's another one way down here. There's another one just like that.
Yeah, and before planning was doing it.
Yeah. That's okay. We figured it out.
So I think that's which makes sense because
I know.
That's its immediate adjacency.
What would you do?
What's that?
What would you do?
So I'm looking right now at this. Okay, so
I push it back.
Look at this. look at the setback right here.
Yeah. Just do redesign, push it back in, and if required, then come back with a rear yard setback.
So surely there must be something in the middle
Because
between this and this.
what planning has come back with is just the concern about the.
Just, in other words, eliminate the front yard setback, so he's stuck with what the zoning 8.3.
Push the building down.
And then if he wants the bigger house, he's gotta go back, and if he needs a rear yard, he needs it. If he doesn't, I don't think he will.
I don't think he will. I don't think he will. That's
Well,
why,
the other thing is number 25.
just eyeballing it.
I mean,
And the old lady in the south loses.
Oh, she loses her, some part of her garden, but there's one way.
But no, this extension is north.
No,
Last time I checked.
there's no
sun-
impact.
It's just a.
No sun impact.
No. And then planning's happy. Well, I don't know if they're happy, but. You won't, I don't think.
So we approve it,
So
we-
I would have this be slightly, so I would have this in line with 25, the structure, this one, this part, this whatever, part B or part A.
Yeah.
And I would move this a little bit forward, just so that, because it is right on the angle.
But we can't define a little bit, right?
That's right.
We can't.
That's why.
You can't arbitrarily say, what would you, 7.5? What do you say? You can't.
Exactly. That's what I'm saying.
No, it's not up to us to decide that.
No.
No. So you just,
Defer.
well, I don't think so. I think you refuse variance 3 and you approve the consent and the rest of the variances.
I think we approve the consent.
I'd like to approve variance 3 on.
You'd like to approve what?
Oh, turn up your mic. Okay.
We good?
Yeah, I think we got it.
I think we got it.
Through you, Mr. Chair, I think my question to you is if we ask, if the motion is going to be a refusal motion, then we would like to defer.
It is not going to be a refusal motion.
We figured out how to split the hairs on it.
Okay. I will.
Listen up.
Okay, so since I started this mess, I guess I'll try to complete it. I believe we have, the severance is definitely desirable. It certainly meets the test for a severance. There's no question about that. The issues are around the variances, and I believe that we can provide approval that will substantially meet the 4 tests. Let's put it that way. So I move approval of the severance and of all of the variances requested for Part 1. However, I move approval of the variances for Part 2 with the exception of variances 3 and 5. So we're refusing variances 3, 5, and I guess 6 in Part 2. but approving 1 and 2. And that, of course, will be subject to forestry condition 3 in both cases, and the usual ECS conditions of severance. Is there anything else? I think that was it.
So we've got part 1 and part 2 figured out. Part 1 is north.
Part 1 is the north, so we're approving all of the variants. At least that's what I'm proposing. Correct.
Yes.
Yeah.
That's right.
We'd like it more in line with number 25.
Well, that's up to them how to figure out how to do it. Is there a seconder?
Is there a seconder for Mr. Clark's motion?
Yes, I'm happy to second that.
Ms. Alderson? Okay, we have a motion and a seconder. All in favor? That's carried unanimously.
Thank you, Mr. Chair and committee.
Are you happy with that? You can work with that.
I think we can work with it.
Good.
I mean, you can at least move forward with the process while you're tinkering how to figure out.
And through you, Mr. Chair, just to clarify, part 2, the approval included the side yard setback variances as well, correct? Okay. And the window baying closely.
Yeah.
Okay.
Yep.
Thank you very much, Mr. Chair, committee, staff. Have a great evening.
You owe us 2 simple ones in the next 2 weeks. Take your pick. Okay, I need a motion to adjourn.
Oh, that's my happy motion.
All in favor? Unanimous. I declare this meeting adjourned at 5:17 p.m.
It's only because you were